let's continue with our afternoon session of our FutureLaw conference. I hope you all had a chance to fortify yourself. We have a series of amazing talks for you all on some of the most important topics and new projects that I'm sure you all will be interested in learning about. Normally the lunch break is a time when we all connect with old friends and make some new friends and build some new connections. I hope that next year at the latest we will be again able to do that. But so we will have our LEX talks now, which will feature our Codex fellows and other thought leaders presenting some important new projects to you all. And the first session of LEX talks will be moderated by Nicole Shanahan. So Nicole is a Codex fellow. She was a residential Codex fellow a few years ago and started a number of important projects during her time at Codex, while at the same time building her own legal tech company, and which is a tech company in the IP space. So Nicole will be emceeing the LEX talk sessions, and I will turn it over to Nicole.
Thank you, Roland. Thank you for having me, and hello to everyone. Thank you to the programs team for putting this all together. It's been running super smooth. And can I just say, I really missed my sandwich and cookie from lunch, and I hope that we can all see each other next year. So in preparation to MC this year's LEX Talks, I realized there's a common theme connecting all of our speakers. And no, it's not that they all have spent the last year working from their slippers and have an affinity for eclectic Zoom backgrounds, although I imagine such is true. What connects these speakers, and more so their work, is the emergence of newly defined subject areas that I anticipate will enter the vernacular of legal tech study and practice in the coming years. We are clearly beyond the founding principles of computational law, and our field is intellectually expanding in new and important ways. We are exploring for the first time the intersection of social physics and legal studies, defining standards such as AI explainability and law time. We are thinking through new strategies for diversity and multi-jurisdictional access to law, and I believe we're finally entering a golden age. In introducing our first LEX talk, I reflect on my personal journey, explaining and mostly failing to explain how my own company's AI works. It is daunting to be both highly accurate and understandable when describing the functions of a specific neural network or computational system. Our first speaker today is working to define how explainable AI should look and feel for legal AI. Katie Atkinson is the Dean of Electrical Engineering. Katie, please, oh, there you go. Oh, great background. See, eclectic. So Katie is the Dean of Electrical Engineering, Electronics, and Computer Science at the University of Liverpool, and will be discussing automating the explanation of legal reasoning, highlighting gaps that must be addressed by future systems to ensure that accurate, trustworthy, unbiased decision support can be provided to legal professionals. And I, for one, look forward to the day when I can hit a button and receive an explanation of why a tool gave me a certain answer. Please welcome Katie. Thanks, Katie.
Thank you very much. I wish it was looking as sunny as that background suggests in Liverpool today. Well, thank you to all the organisers for inviting me to speak at this panel today. In the interest of doing my utmost to stick to the schedule, I have only one slide today that I'm going to be using to make a number of summary points about the topic of explainability for AI and law. And the points that I'm covering in this slide are reflections on my recent experiences from working to develop and deploy explainable AI technology for the legal domain. So let me just share my slide. Hopefully you see that in presentation mode. Okay, I'll assume everybody can see that, and I can go.
Yes, you're all good.
Lovely, great. Thank you very much for confirming. Off we go. So today AI has advanced to the stage where it's already being deployed in practice in a wide range of domains. And in the legal domain, there are tasks that have been shown to be undertaken or assisted effectively by AI programs. We've already heard a lot today about computable contracts, but there's also been success with other tasks such as information extraction and e-discovery. And AI technology for other complex tasks involving predicting legal case outcomes is not yet mature enough to be deployed widely in practice, though there are clear steps in this direction in both the academic research literature and also in commercially developed products. There are a number of reasons as to why case prediction software is not yet broadly deployed, and I'll touch on some key reasons within this talk. But first of all, consider a specific AI application scenario, as you can see depicted up there in the top left-hand corner of my slide. So suppose we have a software-based decision support system that's being deployed in a setting where legal cases are being decided. That might be either a court setting or it might be a case that's being considered by a law firm. We have a complainant who submits their case. Then we have the arguments for the plaintiff and the defendant being identified. And let's suppose we have a tool that advises the judge or the lawyer dealing with the case on a decision as to whether that complaint is upheld, finding either for the plaintiff or the defendant. Any such decision support software needs to be accurate, consistent, and importantly, be able to answer the question of why when asked by the human to justify the decision that has been made. As is often the case with academic research, new lines of investigation on open problems focus frequently on solving some technical challenge. For example, developing techniques to enable AI programs to debate and argue with one another, and that's actually what my own research focuses on. When these techniques are sufficiently well developed and evaluated, they can then start to be deployed in practice. And it's often at this stage that new challenges that are non-technical in nature become apparent, and these often weren't at the forefront of the focus when the original technical solutions were being developed. And we've seen a number of such challenges becoming apparent over the past few years as the AI technology has matured, and I'll briefly point to a few illustrative examples that are covered on this slide. So I'll start with the UK legal system, but I'll also refer to a wider set of examples. We have in the UK, the Law Society for England and Wales, who created a Technology and Law Public Policy Commission to specifically examine how technology, data and computer algorithms are being used in the justice system and to identify the possible risks presented due to rising concerns around fairness, discrimination and opacity. This study resulted in the production of a report in June 2019 titled Algorithms in the Criminal Justice System, the cover for which you can see in the bottom right-hand corner of my slide. That report recognises the potential benefits that these new technologies can bring to the justice system, but also looked at a number of concerns about, and I'll just quote from the report here, reduced transparency in decision-making, leading to a lack of proper scrutiny and greater potential for abuse of power. And that's just one of the concerns within a set of ethical issues around the deployment of AI in practice. So given these concerns, recommendations are now being made about the need to educate and upskill legal practitioners on AI topics. And if we look now at the the bottom row in the middle there, we've got another example where there's a quote from a recent panel discussion at the American Bar Association's Tech Show, where it's stated there that all lawyers must understand artificial intelligence, its usage, limitations, and ethical considerations. So I've been at a number of events, and I'm sure many people in the audience have also been at similar events where there's been debate as to whether or not lawyers should be taught coding, whether they should be taught fundamentals of AI and data science. And there has been plenty of courses that have sprung up aimed at the next generation of students who want a multidisciplinary education that covers both law and computing topics. And we only need to look at offerings such as those from Stanford to see how these are becoming more popular. However, we've also got a large swathe of legal practitioners who are not versed in AI and machine learning already. And any AI-based tools that they are going to be asked to start to use in practice have got to be easy to learn and easy to interrogate as well. And a key consideration here is that when an AI-based tool makes a decision or gives a recommendation, as in my earlier example, the user must be provided with a clear, interpretable explanation for that decision. And this right to explanation is captured in that quote that I've got down there on the bottom left-hand corner of the slide, attributed to researchers from the Alan Turing Institute around this right to an explanation. And a lot of those ethical concerns have arisen around the so-called black box nature of many of the technologies that are receiving attention in the legal tech and also in the wider AI community. And these techniques are labeled as black box because the data-driven and machine learning techniques that are being applied to legal data sets to predict outcomes can't provide an explanation as to why a judgment has been found either for plaintiff or defendant in the same way that a human does give such an explanation. And this concern is one that I've certainly encountered myself when working with law firms to deploy AI techniques for assisting with their legal work. So what should be done about this black box? Well, the issue is one that is of relevance not only for the legal field, but it's also of great interest in the general field of AI. It might well be that black box techniques are less of an issue for specific tasks or deployment scenarios where reasoning and explanation aren't needed. And I note that Thomas Kim's opening talk mentioned that different stakeholders might indeed require different explanations at different levels of detail. So that's certainly something to keep in mind. However, there are tasks where explanation is essential, such as that in that opening example that I referred to, where there's a need to justify why the arguments for one particular side in a legal case are stronger than the arguments being presented by the opposing side. And these explanations are needed to ensure that principles of justice are upheld and also to engender trust in the end users who are going to be using these AI tools. And that's exactly why we're seeing the production of standards and directives on the responsible use of AI, again, also mentioned by the opening speaker. And that's what I refer to in that top row there, in that middle example from Canada. So with the frameworks that are being put into place to guide the responsible use of AI, there do remain technical challenges to solve around the production of AI techniques and software that indeed can be shown to uphold these principles. There's no single solution to this, and within the AI and law community, we have researchers working on a variety of approaches for developing explainable AI. We've been undertaking work on this at Liverpool. Liverpool campus is pictured there in the top right-hand corner. A reminder for myself as well as for everybody else what campus looks like. It's that long since I've been there. But our work involves the use of what we call computational models of argument to replicate the factor-based reasoning that humans engage in when they undertake legal case-based reasoning. And we use formal models that are transformed into software to capture key concepts within legal domains. And these are now allow cases to be compared and decided on the presence or absence of legally relevant factors and the interrelation between these that's needed to be considered for deciding the case. Then once the case is decided, our software is able to provide an explanation of the decision in a format that's close to natural language. And with a nod to the prize winner's speech that we heard prior to lunch, I hope Bob Kowalski will be pleased to hear that we started with prologue implementations of these formalizations. But we're not the only ones working on this. There are other researchers using different techniques to address the explainability issue. Some of the pioneers of deep learning are working to build causal learning into their machine learning mechanisms, and that's currently lacking in a lot of the approaches and proving a hindrance to explainability and trustworthy issues that I already spoke about. We've got other researchers in the field taking a different approach. Notable example is Carl Branting and his group at the MITRE Corporation, who are working on semi-supervised methods to exploit structural and semantic concepts in case corpora to identify patterns with predictable relationships to case decisions, and therefore they offer explanatory benefits. All these topics and approaches have collectively become of such importance that we now have whole events dedicated to the topic of explainability in AI and law. And the final excerpt that I have there on my slide is one from an upcoming workshop at the International Conference on AI and Law on the topic of explainable and responsible AI in law. That workshop's going to cover a wide variety of topics on this issue in recognition of the urgency of addressing the need for explainable AI solutions from both a technical and a societal perspective as well. So to conclude, I believe that we have now got to a stage with legal tech where in order to make process with getting all this exciting research that is going on actually used in practical settings, it's going to require engagement with a broad spectrum of stakeholders who are working on explainable and responsible AI and law. If we're successful in these collaborative efforts, we can work towards the common goal of contributing to the development of AI tools that, when asked that question of why did you come to that decision, they will always be able to say because, followed by a full justification.
Awesome.
Thank you very much. I hope I'm within my time limit.
Yes, that was fantastic. And I just want to add, Katie, even though you don't have sun in Liverpool, you will always have the Beatles.
Indeed, and the museum's actually not far out of that shot there as well. The Beatles Museum.
Amazing. Well, thank you so much for joining us today. It's really exciting work.
Thank you.
Take care. Okay, so our next talk will be covering computational antitrust with Professor Thibault Schrepel, who is the assistant professor at Utrecht University of Law, and he is also a faculty affiliate of Codex. So this idea of law time, coined by Judge Posner, is used to describe the excruciatingly slow time it takes for law to evolve to meet the demands of the new economy, which is today mostly entirely tech-enabled. When we talk about antitrust law and tech conglomerates, we know that completing a complete antitrust analysis requires massive amounts of data review. And that growing scale of analysis is something that seems to be moving further and further away from the capacity of governments and law offices. Thibault will explain to us this issue as it stands today and hopefully leave us with some hope that his Codex project will bring antitrust law in line with the reality and scale of modern corporate activity. Please welcome Thibault.
Hello, can you hear me well?
Yes, you sound great. And again, yet another great background. I'm just not on here.
No, and unfortunately, indeed, when you said, looking for backgrounds for Zoom, that's something I dedicate a few hours here and there. So I recognize myself in that. So if you can see my screen, that would be great. And so indeed, I'm here to discuss a Codex project. So I'm a bit biased, and I hope that you will be as well, entitled Computational Antitrust. And I thought that I will be proceeding as follows. First, I will explain why do we need computational antitrust, although you already mentioned that. Then I will explain how we could do that in just a few minutes, and when do we do it, and how can we proceed. And so as to why do we need computational antitrust, you already quoted Judge Posner. And indeed, in the field of antitrust, we know that we have a problem, which is that the time of markets and technology is going much faster than the time of the law. And this was written in 2001. And at the time, Judge Posner was saying that this was troubling, but I believe that it has actually became problematic. And if you look at the number, we know that already the detection rate is very low, which means that if you infringe competition law or antitrust, chances are that you will be fined, most likely, unfortunately. And as a result, what we see is that 80% of cases before the European Commission are coming from reactive methods, which means that it's basically a company complaining about another company engaging in a practice infringing antitrust. And it amounts to almost 90% in the US. So competition agencies being proactive is not something that they do. And they actually say that they cannot be proactive because indeed, they have no choice but to deal with merger control. And that is taking more and more of their time and resources. I know in the US, it is being debated that the FTC and the DOJ will get an increase in the budget, but this is still something which is being discussed. And in any case, we see that the budget of all agencies have been pretty much stayed the same in the past decades. So that's the state of where we are right now. And I suspect that it could actually get worse. So this is not yet the positive part of my talk that you mentioned, but the negative part of my talk to scare you. And the reason why it might get worse is that if we consider the amount of data being produced all over the world, we see that there is not only a sharp increase, but an exponential increase. Last year or 2 years ago, we produced 33 zettabytes. So I had to look it up on the internet. A zettabyte equals 1 trillion gigabytes. So let's agree to say it's a lot. And in just a few years, it will be 175 zettabytes. And as you can see, in 15 years, more than 2,000 zettabytes. And so for that reason, it is safe to say that for competition agencies, it is actually becoming very complex to find infringement of antitrust. And even after the detection, we have another problem, which is the problem of the analysis. We know that, for instance, the CMA, which is the UK competition agency, got access to Google and Bing search queries for 1 week, and they had to analyze between 3 and 4 billion different search entries. So the amount is quite huge. And the quality also of the data is something problematic. For now, we basically take pictures of the market and we analyze pictures, but as we know, markets are movies, and this is also creating some issues. So I think it's safe to say, and I suspect we may have a consensus around that idea that antitrust is not going very well in that respect, and potentially we can actually improve it. And we have two solutions. We can rely on the market or say, let's prohibit everything ex ante, but even then you would need to detect infringement, or we can rely on computational antitrust. And as you suspect, I'm biased and I prefer computational antitrust. I put George Costanza on the screen, so I'm not alone. But hopefully I can convince you that it is the solution and the path we want to take. So the question is, how can we do that? And indeed, if we agree on saying that antitrust without computer science is Sherlock without Watson, the question is, but which Watsons do we need? Because there are lots of different types of Watson, and some might be easy to implement or really hard to implement. And I thought I would give you just two examples. The first relate to anti-competitive behavior, so cartel or monopolization. It seemed clear that if you were to use market screening tools, you could actually detect more practices. And we have a few agencies doing that here and there, but still on a very small scale. You could also think that using NLP, you can analyze a company's public documentation and that way detect infringement to antitrust. When it comes to the analysis, well, as I said, if you need to compare millions of documents, in any case, you have no choice. But why not also taking the data and the information coming from other agencies, such as the SEC in the US, and use that for competition purposes? We have a few papers showing that this is possible and very much relevant. Another idea is to actually take data that we know competition and antitrust agencies have for a fact, which is their own case law. If you are to train an algorithm based on their case law, potentially they could detect new patterns that they have never seen. And that's actually what Mazzarotto and Itu have done for a paper that they published within the project. So that's one case use. Another one, as I mentioned already, is the one of merger control. And here the issue is a bit different because there is no detectability issue. Most companies will indeed notify the merger if they have to. But the issue is that agencies have no choice but to take a decision, and usually within less than 100 days. So we have an issue when it comes to the procedure. We also have an issue when it comes to the analysis. In one case, Bayer Monsanto, the European Commission had to analyze almost 3 billion documents. Imagine doing that in just 90 days if you have no tools. Potentially, we can also think about using agent-based modeling to try to create millions of different subjects and see how they will interact. And we have another issue, which is the one of asymmetry of information. And indeed, many times agencies will complain, and sometimes publicly in press releases, that when companies are sending information, they will delete some information out of the databases. So why not using blockchain to make sure that the integrity of the databases is maintained? So those are two ideas that I wanted to submit to you. Of course, there are many more, but now in 2 minutes, I want to explain. So when do we do all that? And I guess it's fair to say that, well, the answer should be and is already now. And we have a few examples that I've listed on the screen here. I think it's fair to say that the CMA in the UK is the leader in the field with 50 computer scientists. But in any case, it's growing rapidly, and this may change in the coming weeks and months. And in the project, we actually brought together 54 competition agencies agreeing to work with us on those issues. So that's when it comes to the positive part of my talk today. So what do we do within the project? Very concretely, we publish one article every month, then a podcast episode, which goes with a paper. We have one, by the way, coming tomorrow morning or during the night for you in California. And then we're going to organize a workshop with all of the agencies in which the agencies will exchange ideas, and then they will send us a short report on all of the implementation they've done of computational tools within the year. All of that will be made public, open access on our website. So far, we've got quite a few support, and we are very grateful for that, coming from official press releases to the New York Times. And yes, if you may see one of us in the team, we may be doing this phase. And the question is, why are we making this phase? And the reason is that because we are facing quite a few challenges. The good news is that we like challenges, so we smile. And let me just tell you about the challenges. Number one, which fields of computation of antitrust can you compute? And the answer is not all of them. Sometimes public information is not enough, and it's really hard to calculate antitrust. Challenge number two, which tools do we need? How to fit the tools? Challenge number three, the role. And indeed, Akerlof actually said in a paper recently that in the field of economics, we tend only to rely on mathematics, and everything that cannot be put in a mathematical model is being disregarded. We want to avoid doing the same in the field of antitrust and disregarding what is not computable. And the last challenge is to know the limits, because the idea that we can create a theory of everything, even thanks to quantum computing, I think is far from being true. So at the end of the day, there is hope that we can actually merge the substance and the methods. We have challenges ahead of us, but the best news, I would say, is this one, is that indeed the project is located within Codex, and I wanted to take just a few seconds to acknowledge the support of Roland, because indeed, I think we are very lucky to be in the only center where we could actually match that expertise. And so again, the future of antitrust, I think, is bright. And for that reason, again, thank you very much, and I look forward to your question.
Thank you. We have time for questions, about 2 minutes. Well, I guess I'll ask a question, Thibault. So what kind of data sets do you think you'll be spending the most time with?
Well, I think starting with the antitrust agency's own case law is an evidence. And this has been done in a paper that we published for the FTC. They trying to train a unsupervised machine learning algorithm with the FTC and the DOJ, and it's not working because the case law is too different. So we probably need to do that for each jurisdiction. When it comes to market scraping, I mean, that's something also that we could do and detect potential collusion. So collusion between companies, I think, is also an obvious space that we may want to investigate. And the last I would say is merger control. Merger control basically is still printing papers, sending papers to the agency. The agency will read the papers. I mean, it looks a bit like something we were doing 40 years ago, and I believe we can improve that very easily. And you know, in the discussion that I had with the competition agencies, it was always the number one thing they were asking me, what can we do starting today? And I think in the field of merger control, we're going to see some rapid changes in the coming weeks.
We just had a question come in from Carlos. He's asking what sources are being considered for computational antitrust besides the web. I think we kind of answered that, but yeah, if you have anything quickly.
So sure, what I want to say is that you could use computational tools for but at least two different things. First, to detect potential infringement. And then once you have done that, competition agencies and antitrust agencies, the same is true in the US, they have the power to go to the company premises, take the document, and then do some sort of other analysis on private information, whether it is NLP or something different. So it's first important to detect, and then we can actually use many more tools for the analysis to be improved and probably, hopefully, a bit less static, because today it is very much static.
Wonderful. Thank you so much, Thibault. Very important work and beautiful background. It's very accurate for this area today.
It is coming from California, indeed. So thank you very much.
Awesome, thank you. Okay, so our next talk will be about diversity in the field of legal tech. The presentation's coming from Kristen and Pieter. Kristen Sonday is the COO of Paladin, which is a law firm platform that helps lawyers access pro bono opportunities efficiently. And Pieter Gunst, who is the CEO of Legal.io, which matches in-house legal teams with external counsel. Pieter is also a Codex Fellow. In my research for this talk, I learned something interesting, that in the gaming world, a paladin is often depicted as a spiritual warrior whose divine powers are karma-based and available through the chivalry system. And if that is not a statement on ethics, then I don't know what is. True to the theme, Kristen and Pieter will be discussing the current state of diversity among legal tech founders, leveraging data from the Codex Tech Index, which Pieter first introduced to us all a few years ago at FutureLaw. The talk is also a continuation of Kristen's work that she started in 2018. They will provide some strategies to increasing gender and racial diversity among legal tech founders and the legal industry at large. Please welcome Kristen and Pieter.
Thank you so much, Nicole. And hello and good afternoon, everyone. My name is Pieter Gunst. I'm a Codex Fellow and the CEO of Legal.io. And it's my pleasure to present at this Codex Law Education and Experience talk together with Kristen Sonday. For those of you who are regular attendees of FutureLaw, now in its 9th edition, you may recall some of the previous lunchtime talks covering the Codex Tech Index, accessible on the web at techindex.law.stanford.edu. The Codex Tech Index was created by Stanford Law students as a project during the Stanford Law School Code is Law sessions, which introduced students to the basics of programming, from creating a GitHub account to writing HTML and JavaScript to working with databases. The Codex Tech Index was one output of these learnings. Since 2016, the Codex Tech Index has curated data on now over 1,700 startups and companies that are changing the way legal is done. 5 years later, the data set has been used by dozens of projects, from state bar research committees to top-tier VC funds to legal operations teams, to gain an overview of and insight in the legal technology landscape. About a year ago, I had the pleasure of being introduced to Kristen Sonday, who had released a study in 2018 investigating the diversity of legal tech founders, the people actually building these companies. So another opportunity presented itself to leverage a subset of the Codex Tech Index data to drive additional insights and hopefully action. And this is what we want to talk about with you today. In preparation for this talk, Kristen asked me why I believe that this conversation matters. And I have to say, it's personal. I've had the privilege of growing up amongst two brilliant female scientists, my mother and my sister, and I've seen some of the challenges that they run into. I have the distinct pleasure to work with an amazing co-founder, Hanna Konicek, but the data Kristen will present shows that it's simply harder for female and diverse founders to get access to the capital, networks, and other things they need to be successful. And this needs to change. In addition, I believe that this conversation is especially important when it comes to legal tech, when considering the laws and the code that will shape the future of the legal system and the profession. The only successful strategy will be the one that embeds the perspectives of all stakeholders in the system. Kristen, I'll hand off to you now to dive into the data and how we are doing in this respect.
Great. Well, thank you so much, Pieter, for that introduction, and overall to Stanford's Codex for having me. So really our goal for this study was to understand who was building legal technology, looking at folks' backgrounds across a variety of criteria. So for this refresh that we recently did, we wanted to drive home the question of who's driving innovation and progress right now, narrowing down our initial scope of companies within the database to US-focused, full-time standalone technology companies that were founded within the past 10 years. All in, we ended up researching 392 founders across 219 companies. So the synthesis in comparing this data to a couple years ago is that we are making gains, although they are very, very slow. So overall, we saw a slight decrease in the number of founders of color within legal tech, down from about 127 to 124, so again, very slight. And then we also saw a decrease in the number of female founders, down from 66 to about 57. This is over the past 2.5 years or so. However, these numbers actually represent an increase in representation across all founders in legal tech. So we saw diverse new founders making up about 31.6% of founders now, compared to 26.5 a couple years ago. And we saw a slight increase in the representation of female founders from 13.8% to 14.5% now. Again, very small and significantly underrepresentative compared to the general population. Okay, so why does all of this even matter, diversity among legal tech? So in my mind, the purpose of legal technology is to make law more accessible, right, to both clients and lawyers alike. And to me, the future of law is technology. And so those who shape legal tech, they're really shaping the future of justice. Currently, about 86% of low-income individuals' civil legal needs in the United States are not met, and that disproportionately affects women, immigrants, and minorities. Given that justice gap, legal tech founders have immense power and responsibility to make sure that they're including these voices in their tools to really end up building products for those in need who are typically left out of our judicial system. Diverse leaders, there are a number of studies around this, they are going to raise issues that other people in the room wouldn't consider. They're going to end up hiring more diverse teams. They're going to contribute more diverse viewpoints. And ultimately on the business side, studies show that they're going to produce better financial returns. So put simply, by decreasing the design bias that we have in building legal tech through diverse and female founders, our technology is going to become more comprehensive and impactful as a whole. And especially as consumers become more diverse, our country is going to be majority minority by the decade 2040. It's really essential that these backgrounds and experiences and use cases are reflected in the tools for the populations they're ultimately going to be serving to really address critical legal issues. Okay, so what can we do as a community about the lack of women and diverse founders? So if we are serious about moving the needle, as I believe we should be, the first thing that we need to do is really make sure that our current group of legal tech founders is really successful. And if we do that well, then we're going to do 3 really important things. The first is that we're going to change the pattern recognition of what success looks like in legal tech to both buyers and investors, which is really important. The second is that we are going to inspire others to start companies by visualizing what that representation looks like. And then third, we're going to create generational wealth by investing in diverse founders and increasing that investment across the board. So I've laid out 7 steps, you might have heard me say elsewhere, of ways that we can all get involved and really support Black and brown and diverse founders and women in particular. So the first is that if you can be a client, buy their product. The second is that if you can invest, write a check. Obviously not everyone can do that, but we've had checks as small as $5K in Paladin up to much more. The third is if you know decision makers, make an introduction, since that one initial introduction or kind of flagship partner can really be everything to a founder who's starting out. The fourth is if you are on social media, as we probably all are right now, tweeting about these sessions, just share or like the company's posts, because really elevating their voices and amplifying what they're working on is so important to providing legitimacy. The fifth is if you're a journalist, please write about or interview these founders. Bob Ambrogi did a tweet the other day about how he wrote an article about an up-and-coming founder who ended up getting an investment from his article, which is really incredible. Love to see more of that. And then lastly, if you work at a law school, invite folks to present to students. Those platforms, again, are so important for helping to amplify these voices and that work. So the second part of advocacy is to encourage more diverse folks in legal to just get as much exposure as possible and really make sure that these voices are heard in these conversations. So that means exposing your team to legal tech companies, hosting innovative speakers, encouraging them to try internships or externships at legal tech companies, promoting demo days and pitch nights, and really just sharing relevant content that might inspire them. And I know, Pieter, you work on the hiring side, so would be definitely curious to hear your recommendations for what folks on the legal side can do to really ensure that diverse voices are in the room, they're being heard, and they're being hired and promoted.
Definitely, Kristen, and those are amazing notes. And I'll reinforce the point around pattern recognition. As someone, trained in law and coming out of the big law world, I've seen firsthand the power of seeing others do it. And I agree, it's so crucially important. Now, as you noted, as founders, we also have the responsibility to build strong teams. And our company, Legal.io, helps enterprise legal departments hire legal professionals for temporary and permanent positions. So this is a topic we think about a lot. And it really comes down to creating repeatable processes and then ensuring that they become an integral part of company culture. One way to achieve this is to implement D&I rules as part of the hiring process. For example, as part of our hiring processes, we implement an equivalent of the Rooney Rule. And the Rooney Rule is an NFL policy that requires every team with a head coaching vacancy to interview at least one or more diverse candidates. It stemmed from the observation that the player base, the workers, were much more diverse than the NFL coaches, the management. Does that sound familiar? Practical implementation of this strategy requires that you're intentional about hiring sources. It requires going beyond your LinkedIn network and the people like you that you already know. And this is true whether you're building a legal tech startup, the founding team, a law firm, or a legal department. Another example of a strategy is the Mansfield Rule, which has found traction in law firms. It's inspired by a winning idea at the 2016 Women in Law Hackathon. And it measures whether law firms have affirmatively considered at least 30% women, lawyers of color, LGBTQ lawyers, and lawyers with disabilities for leadership and governance roles, for equity partner promotions, for formal client pitch opportunities, and for senior lateral positions. So the goal of the Mansfield Rule is to boost the representation of diverse lawyers in law firms' leadership by promoting and broadening the pool of candidates that are considered for these opportunities. The rule's elements and operations, they're grounded in behavioral science research, including the 30% requirement, which researchers have found is the critical mass necessary to disrupt biases within an organization and a conversation. And as Alan Key quoted this morning, we see things as we are, not as they are. So through implementation of strategies such as the Rooney Rule and the Mansfield Rule, a company can avoid bias by ensuring that diverse candidates are considered as part of the hiring and as part of the promotion process. Now, it also takes ongoing and conscious effort to ensure that diverse voices on your team are heard. So having allies in meetings reaffirm what people of color or women say, asking them for their opinions when they are not the loudest voice in the room are good examples of this. Processes like this really make a difference, and they're helpful whether you're building a small founding team or you're expanding your Fortune 500 enterprise legal department.
Great, I love that. Yeah, the allyship and the community is just so important to making sure that we're all collaborating and lifting each other up. And just one note that I'll end on is that, where we are at Paladin is one of the few kind of justice tech companies. We're really starting to see an increase in opportunity for diverse founders in particular to be building companies that ultimately serve diverse populations in a scalable way like never before. But again, we need that community and that collaboration to really support and lift up these founders. So that I think is the really big opportunity right now that's kind of up and coming. And I would encourage everyone to get involved, do some reading, get online and support, even with just amplification as much as you can, because that's kind of the next frontier of where we're going on the justice tech front.
Great, thank you. One question's come in from an anonymous attendee. And based on the question, I'm wondering if they're like 18 years old. Please do disclose. But they're wondering if there is information regarding age diversity.
Yeah, that's a great question. So we don't have access to founders' ages. I suppose you could go through their LinkedIns and figure out like when they finished college, graduated from college or something like that. So unfortunately, we don't have that information. One thing that we did measure that might be of interest, it's not exactly related, but we did take a look and see if whether folks had a JD or not, and found that about 60% of founders did not have a JD. So when we think about, who is shaping the future of law and, what that demographic breakdown looks like, we really do need people of all different backgrounds and ages and backgrounds in a number of different ways to make sure that we're collaborating on solutions that work for folks really across the board, technical or not.
That's wonderful. Well, thank you. And I hope that in a few years, we will see more change. And one question just came in. It was more of a comment, but I think I might leave that one for you guys to answer in the Q&A section. Thank you so much, both of you.
Great, thank you.
Okay, so next up will be Professor Dan Katz, professor at Chicago-Kent Law School and Codex affiliate, as well as Dirk Hartung, Executive Director of the Center for Legal Technology and Data Science at Bucerius Law School in Germany, also a Codex affiliate. They will be presenting on two recent papers. The first is Complex Societies and the Growth of Law, and the second is Measuring Law Over Time. In this, they will be sharing exciting results collected and analyzed in partnership with the Legal Data Science and Research Group at Bucerius Law School. It sounds like this project was a massive undertaking and a great example of collaboration within our field of legal tech. The introduction of social physics to legal tech really jumped out at me in their work. And I hope this leads to further exploration of the intersection of perhaps even quantum physics and the legal field, and great example of the intellectual expansion happening. Please welcome Dan and Dirk.
Well, thank you very much to the organizers for having us here today. I'm going to share my slides and make sure that's all cooking. Are we good? I'll assume somebody will tell me otherwise if we aren't. So as Nicole mentioned, this is our research group, and I want to acknowledge Dirk and I will be here today, but I want to recognize Giannis, Mike Bomarito, who's Codex Fellow, and Corinna from Max Planck Institute, who are our broader research team that worked on this research under the auspices of the new Bucerius Center for Legal Technology and Data Science in Hamburg, Germany. And in terms of the themes of the conference and the relationship between this work, I guess I would say that, we see this relationship between legal complexity and legal innovation as a fairly strong one. We believe that legal complexity is one of the big underlying dynamics for our space. That kind of the historic model in law is anytime you see complexity, just throw more people at the problem. And the challenge is that the ability to scale people has not scaled as fast as the complexity of legal rule systems. And therefore, that's sort of the entry point for legal technology, design, informatics, and process engineering, or just any way of working differently in response to kind of increasing legal complexity. So the bit kind of, again, this is a short talk. There's quite a bit in here, so we'll just kind of give you the appetizer version of this here today. But sort of what is legal complexity, and then more generally, how might we characterize or measure legal complexity? Because I think it's a thing people would acknowledge is there, but it's hard to characterize fully. So this has been an interest of Mike and I's for over a decade. About 10 years ago, we wrote a couple of papers on this, focusing on just one snapshot of the U.S. Code, which is the federal statutory law of the United States, just for one shot, 2010. And we did some analysis and was published in AI and Law. In this paper, which we released late last year, was published in Nature Scientific Reports and is available open access to anybody who's interested. We did something much more grand in the sense that we, instead of doing 1 year, we did it for 25 years, and we did it for 2 large industrialized countries, the United States and Germany. And just to kind of give you an idea of how do you model how one might model the law as using kind of in a mathematical sense. Well, one thing that legal systems, statutory systems have is a rule hierarchy. So I'm showing you here the German Civil Code, and you can see I'm tracing on the side how that might be represented as a hierarchical, as a hierarchy, but it's not just a hierarchy. There's also cross references that exist in here, where one part of the law cites another part of the law because of there's some commonality between them, or the drafter decided to reference one part to another. So legal systems have this hierarchy, they have this reference network, and then they have this sequence graph whereby, one part of the law is that's substantively related is often located near another part of the law. So it's not a random array of provisions. And so that's something you can exploit mathematically when you're trying to characterize things. So if you look at overall in the law of these two countries on the statutory side, we see about 50% growth over 25 years in the number of words, but quite even larger amounts of growth in the structural and in the references contained therein. So here you see that growth in both countries, a little different in each how it lays out in each country, and we'll say more about that in a second. But then the next question is, so where does that growth take place, and how can we characterize it as time ticks forward? Well, one thing you can do is the law itself has a taxonomy that was developed a long time ago of there are titles and chapters. Those were locked in time a long time ago. And so one of the challenges, if you just take you can see how much more connectivity there is between provisions of the law, if you see how much denser the graph is over time. But one of the things is that anybody in informatics, you build a hierarchical taxonomy, and then it kind of breaks over time because the world changes. So you either take that taxonomy or you create a new one. And so we try to say, well, how could you let the data speak for itself and algorithmically create a different type of grouping? So here we went to information science. This is well-known in network science is InfoMap, which is an algorithm, has strong information science foundation. And we applied it to this and sort of let the data speak for itself. And so we reorganized the law algorithmically into these sort of more parsimonious graphs. And what's nice about that, and this is what we show in the paper, is then you can trace these topics over time and see how one set of principles in the law gives rise to new ones, and how we overlay the law over time. And so you can do something like this, which is at one scope of resolution, but you can drill in or drill out. So you can get much more detailed, or you can get even more high level, tracing those cluster families that I showed you in the previous graph over time. Okay, so again, that's the appetizer version. So over to Dirk in Hamburg, who will talk through our second of the two papers.
Well, thank you, Dan. And as you could see, while our previous paper only had federal statutes, we now added all the regulations in the US, that would be the Code of Federal Regulations, CFR, to get a more complete picture, and to also add over 1 billion tokens to the analysis of a bit over 2 decades. Now we presented this at the Physics of Law conference last fall. It will hopefully, it's currently under review, be released in a special issue of Frontiers in Physics. That is edited by Dan, but also by J.B. Rule from Vanderbilt and Pier Paolo Vivo from King's College. And the very fact that we have such a thing in a physics journal shows us that this research is inherently interdisciplinary, and that there's increasing interest also from the hard science side. Now, what is this new paper all about? It's primarily a methods paper written for a technical audience. We suggest a comprehensive set of metrics and methods to measure legal complexity, and then we demonstrate how you apply it to a corpus of all federal regulations and statutes in the United States and Germany. Let's see what we find. In our prior paper, Dan mentioned that we saw growth, and we can confirm that that growth is also here in the time period that we look at here, but that actually the growth in the statutes is dwarfed by the growth in the regulations, at least in the United States. We see 3 to 4 times larger growth, and that's a lot because we had a lot of law in the 90s, and now we have nearly 159% of that. So that's an incredible increase in the amount of law, so words, in interconnectedness, and also in structure, and it's even more pointed in the regulation. We have that data over time on this slide, and you can see that the trend that we see in the US on the right-hand side on top here is not universal, because Germany does not show that. And so we're still trying to figure out what is typical and atypical behavior, and here we see a difference between those two countries. Now remember those families that Dan mentioned, those topical clusters, we have them here as well, but we've added regulations, and we can see over time how the composition between regulations and statutes for each of these topics has changed, with the general trend of the US regulating more via regulations, while Germany makes rules rather via statutes. That's not universally true though, because if you look at housing in the US or environmental protection and workplace safety, you quickly see that we have counterexamples. The interesting thing about the regulations is that one, it makes our clustering better. So more information leads to better clustering, and that new things show up that we weren't aware of before. In the US, energy regulation is very regulations focused, and Germany vocational training, and we did not have the complete picture before. Now let's take it another level down to the individual sections. We're talking micro connectivity here, and there we see that there are different types of sections on the very smallest level, depending on how many references they attract or to how many other provisions they point to. And we can identify particularly sensitive breaking points and important hinges between different regulatory areas. And we can also create rankings, as we see on the next slide, where you see that there is, for example, one piece here that has over 2,700 other provisions pointing to it. So if you make a change here, that will likely affect a lot of other areas. We hope that this is useful for people making laws, but then we think about laws, right? More on a larger level, not individual sections. And how what can we find out about them? So we have created these profiles. You can see here in prior work by Kupet and Fleckner, how in Germany, the Securities Trading Act has changed over time. And everybody sees that it has apparently grown a lot in structure. We were wondering, how can you take this that is visually understandable and bring in analytical tools that require numerical input? For that purpose, we developed these 10 statistics in 5 groups to precisely measure and monitor each individual act, each individual piece of law. This allows for comparisons across document types, so regulations and statutes, over time, of course, and then across countries. And we hope that it's useful for the legislative process because we can understand the actual impact of a new piece of legislation to tame raising legal complexity. We devised these concepts of reliance and responsibility. You can see here initially in a new visualization that Dodd-Frank relies on a lot of statutes on top, while the German Securities Trading Act, for example, is responsible for many other parts of the regulation. And theoretically, you could use this information to find out how a new piece of legislation works, but to also learn something about the regulatory environment that already exists today. There is an extensive case study on financial regulation in the paper, but this applies also to other areas. And now I will quickly talk just for a brief moment about what these networks mean for non-legal scholars, because we would expect from social networks and bio networks and really the internet, bow tie structures, large in-only and out-only component and a smaller, strongly connected component. That has been associated with efficiency, robustness, evolvability on a systems level. And we see that these legal document systems, they are different. They look more like rockets. That's what makes them interesting to a non-legal audience as well. And that's why folks that come from the network science side are interested in this data. Now, with all of that, I hope that we could convince you that in legal complexity research, these advanced methods lead to interesting results from an interdisciplinary perspective. There's a lot that needs to be done. We've only looked at legislative and executive branches and only on federal level. There are other methods to be considered, such as NLP. And of course, as always, a close collaboration with doctrinal scholars to better understand where these results are coming from. Now, folks, thanks for your time.
Thank you so much. What a well done paper and data analysis. One question someone just asked is, what's a node and what's an edge in your work? And I think he's referring to your second or third to last slide.
Okay, I think I can take that. There's a whole data model in the different papers, but it can both be structural items. So the edges can be different things. The nodes typically are individual units of laws, so that would be sections or paragraphs in German. But then also, again, structures, so chapter, subchapter, and all that. And it really depends a bit because it covers all these different document types. But there's like a large explanation of what it is in the individual contexts.
That's fantastic. Well, thank you so much. We're running right on time. And our next talk is all about legal APIs. Professor Houman Shadab from New York Law School will be presenting. And, I think this talk is incredibly timely given we just came off of last week's Supreme Court ruling that APIs are not copyrightable. And this case is thus far the biggest programming copyright case in history. Google succeeded in arguing that APIs should not be copyrightable, and doing so would be a disaster for the economy, creating chaos, encouraging copyright trolling, etc. But in all of the discussion of this landmark case, I kept asking myself how many lawyers really understand how APIs work. And I know when I was selling software to legal professionals, I found myself attempting to explain APIs and analogizing them to, for example, roast chicken recipes or recipes in general. And clearly that's not an effective approach. And so thankfully, Houman will take this time with us here to explain legal APIs and APIs, and very grateful for that. Please welcome Houman.
Yeah, thanks so much for everyone having me. Codex, it's really a pleasure to be here. Thank you to the Supreme Court for listening to my amicus brief to get that ruling down just in time for my panel this week. So thank you for the Supremes for that. But on a more serious note, let's go ahead and get started. I'm going to share my screen. Okay, hope you can all see that. Legal APIs. Houman Shadab here, professor at New York Law School, fellow Codex, and thank you all for being here and those excellent talks before, and certainly all the support to the date and going forward. This is definitely part of my legal APIs project as a fellow at Codex, and so I think a really exciting area for the reasons Nicole just mentioned. Talking quickly about what's an API, why does it matter to law, and then a bit about my argumentative approach and normative analysis about how to design legal APIs, perhaps in a better way, and make them more accessible, and then a live demo, because I'm all about building software and of an API I just built. So really, what is an API? Application programming interface. In a sense, at the highest level, the takeaway is it's the glue for the web. It's how all these software systems interact with each other, whether it's a website or a mobile application or a database, pushing data from one software system to another really makes a modern web work. There's a whole aspect of the API economy that's very important. But getting a little bit more granular here with respect to structures is the design of a REST or RESTful API, which is essentially the more common modern standardized approach to structuring API. So certainly as part of my research, really understanding and explaining the RESTful approach as opposed to others like XML or SOAP is part of it. But really, I think we can take almost as a default assumption these days that if you're talking about APIs and webs and modern web services, you're probably talking about one that's structured in a RESTful interface. And it's the client, the computer, the mobile application, sending messages, sending calls to the API, and really to access someone's database. And that's what APIs are all about, making it easy to access a database programmatically, which means bringing it into your program, bringing someone else's data and or software functionality ultimately into your program as a consumer, and also certainly doing the flip side, creating your own APIs. And there's lots of really exciting opportunities and approaches to saying, you know what, we want to provide software functionality to someone else, including legal tech, to be sure. They don't want to buy an entirely new system. They don't want to buy, importantly, an entirely new user interface. They already have their UI flows ready. They just need some AI to plug in. They need some more information from the external world to plug in, and that's what really an API can make valuable. It definitely makes systems much more easily integratable in more like the business sense, and the practical sense of not having to buy an entirely new software system just to add a few new features or even several new features sort of in the back end through API. So in a sense, an API has no front end, no screen in a sense. It's like organized data, as we'll see. And just a simple example of what does it really mean for the modern API economy and the glue of the web to be there? Well, of course, we know services like Yelp on the internet, they didn't remake and reconstruct from the ground up. Obviously, Google Maps API, Google Maps, they just use their API and bring in data about locations and geolocations and put their data, transpose it onto this. It's not a new idea, certainly, I think, to anyone here. It's basically a mashup. And one way maybe to understand APIs is to think about it's a mashup between one software system and another, or one database and another. But the key thing, too, for APIs is that it's not just simply making data available more easily. In a sense, it absolutely is. But we can obviously do internet searches for Excel files all over the internet, databases all over the internet. What APIs do, and go a step further, is that quote programmatic part. It says we can actually really interact with this data in a systematic, software-driven way according to these standard CRUD operations: create, read, update data. That is kind of database software 101, and do it through the web, through quote unquote HTTP methods, post, get, put, delete, and several others as well. But this really make up the core of the API interface. And I'm going to show you essentially some get calls in my demo. Hey, so what does the API data look like? Well, I think we have already some intuition about what this is. It's not very pretty. I'm sorry, I didn't make JSON structures with all the kind of colons and quotes, but the idea here is that APIs use a JSON structure as a representation of their data. And here's standard case law data coming from Harvard's Case Law Access Project that we will see soon. And it just organizes it more or less like a traditional spreadsheet, but it's a bit more complicated, or at least allows for more functionality as quote semi-structured data. What, in a sense, what is an API as well? It's an endpoint. In the sense that the beauty about APIs is that we do have an intuition of them already, because in a sense they're just websites. And instead of URLs, they're called URIs, but here are the basic components of them, color-coded for your pleasure. We have the protocol, the basic server, the endpoint, what are you basically allowing people to do, or what is the resource, the search? And then queries, you're going to send queries, right? So here you see an API call essentially for Google search that we kind of know and love, right? And you're searching for the word fun in French, and that's the HL is the key value pair part of it for what language it is, and Q for query, of course, for search. Search is the basic functionality that we all understand every day based on how we use the web already. So again, it's these key value pairs that APIs fundamentally work upon, and they're defined by the API maker. Okay, legal APIs. So legal tech is nothing new for anyone here. APIs in general, there's at least 24,000 public ones, and there may be various degrees of functionality, because of course APIs get updated and they go defunct and deprecated, no longer used. But the programmable web is probably one of the better sites that tries to track all the public APIs. So public just means publicly available. You may have to pay for it. You may have to pay a lot for it. You have to have various degrees of authentication and limitations on what you can do with a particular API. But the point is, at least it's not hidden behind someone's database or mainframe or whatever it is. There's some functionality that a company is trying to share or sell with the world that really is part, again, of the modern web. And programmable web tracks that. If you go to like the categories in the programmable web, you will see various legal and law related ones broken up here. One example here in the transactional contract sense is from PandaDocs. And the reason I use this, among so many others, at least for demonstrative purposes, we can see kind of the mapping out of these various endpoints that I mentioned before, where endpoints are the things that allow you to shoot data to an API. One into your and what does that mean in this context? It could mean something like you search. It allows you to search your contracts and perhaps in another database and bring the information back into yours. It allows you to search the tags or to tag things up as well. Again, not by not changing anything in your system's interface. So in principle, you could use this for interacting with your own your own contract management system and bring in PandaDocs additional functionality here. Another one here is with respect to the functionality of the various approval levels of contracts. Again, you can move this into your own CLM system as well, and take it from there. And of course, the X's there are important too, just to note, is because what it's noting is that When someone does make an API, it doesn't necessarily parallel one-to-one for their software functionality. It may not have all the endpoints that correspond to everything that the actual software does. So in any case, I went to Harvard. I want to be in time here. I went to Harvard's Case Law Access API. Wonderful, amazing free resource. Kudos to everyone involved in that project for making so many cases available for the public to search for free. And here's another example. We saw one already from that project of how case law data is organized and structured, again, in a standardized, relatively standardized format at least. And we can have arguments about how standardized this and standardization in law and law technology, of course, and the metadata. But here's essentially another aspect of how API data representing case law is represented here. And in terms of endpoints, where is that data? How is it structured? Back in the same color-coded approach I used before, it's api.case.law. Wonderful URL they got there. And then version 1 and the cases. And then if you do the query for the search, it always comes after a question mark. And then the ampersand would distinguish parameters from each other. But the search is their the key value you give for their search parameter. So search I just use as an example because we're also familiar with searching already. You can obviously search via API, but of course you can do way more. APIs are not just search engines, of course, but that's certainly part of it, an important part. And so in terms of my own research, after kind of laying that foundation, hopefully explaining things, my argument or my theory at least is that law as a discipline, has a common subject matter with respect to institutions and rights and duties, and a unique subject matter should have a unique, unique approach to how APIs in the legal realm are designed. And it's kind of up to me to convince people that that is beyond simply obvious, or at least that what is the best way then to construct an API that deals with legal subject matter, legal institutions, legal consequences. What does it mean really to send, what should it look like in terms of that API structure to send a breach of contract or a fine from one person to another? And that does look a little bit like issues with respect to standardizing metadata. And in terms of, so beyond the structure and methods of legal APIs, I also argue that we want to make them more accessible. And that's what part of this project really is all about, making APIs for everyone, making them available to be used and consumed, also making it easier to build APIs. And that's part of what I'm going to show you now. Just my final few minutes here is, here's the structure of what I'm doing actually, is in terms of the API build very quickly. Here's my legal APIs, the API build. What it does is it sends API calls out into the world, one to the Harvard Case Law Access API to search their case law, one to the United Nations website. They have their own API, but I'm using the Google Programmable Search Engine API just to make it a little bit easier and just to show you can kind of mix and match things and get data different ways, of course. And then I ultimately take that data, combine it, and expose it in an API that you can play around with, but maybe after my talk, please, yourself. I mean, it's a very open, free API, no authentication, super simple, just to get the idea to see that structured data. So let's go ahead and look into my application. There's the actual applications database. I'm going to, it's hard to get around there we go, the Zoom information. Okay, so here's the front end, okay, of the information. Here's the actual API itself. So you see, I did a simple search for blockchain at the United Nations and brought in that data, and that basically parallels what you see here in terms of the search results. And more importantly, this is the data that's being exposed in that JSON, not very pretty format. And so let's go ahead and ping and search for blockchain, which is my default file.
Hi, Houman, you cut out.
That I use, but are you still here?
Oh yeah, you're back now.
Okay, great. Yeah, so I'm just going to search now that the Harvard Case Law Access API, and what I'm going to do is I get that blockchain. Of course, you can search for other terms as well to show you that it is live. I'm just searching for Bitcoin just for fun, but let's go back to the default search term blockchain, which is why you see it there. Let's save it to my apps database. So I just pulled in from Harvard Case Law Access API. I just saved it here. And you can see what's in my database. And I'm going to show you the flip side of it. This data is being exposed through this endpoint. It kicks up my sleeve here. Let's refresh it. And there you go, right there. You have that case. at the bottom. Now you can pull it into your own API for whatever purposes. But the beauty about this API is that it combined 2 streams of data very quickly. And once you learn these no-code tools, it took me less than an hour to even figure this out. And once you know it, it takes a few minutes just to expose your API as a RESTful interface. So thank you so much. That really brings me to the end of my talk. I look forward to pushing this technology forward, making APIs more understandable and accessible, and hopefully in some sense standardizing their approach to being made.
Thank you, Houman. That looks great. What kind of use cases are you expecting from your project?
Yeah, everything from being able to have a more granular approach to searching all these legal APIs and making it much easier. So creating like a very intuitive and useful way to say, hey, there's all this data. We saw the many legal APIs, different court systems, different cases, United Nations, transactional data and functionality. So making those easy to interface with. Also kind of maybe like a meta project, making APIs easy to test. In the first place, just testing the API connection often requires a little bit of tooling and a little bit of kind of coding or understanding of some of the nomenclature, but you can kind of make that a more visual experience to kind of see what's out there, as well as, really anything you can think about in legal tech, just really making all these APIs more accessible and understandable and comparable. And then, whatever purpose you want to use it for, commercial, educational, otherwise, you can make a more informed decision.
That's fantastic. I can only imagine the amount of growth you're expecting over the next few years.
Yeah, absolutely. I mean, the other day I didn't show this. I was relatively quickly able to connect an application to blockchain, to Hyperledger Fabric, just sending data to it, it's being stored there, and then bringing that hash of the data back into my database, which is mutable. You could delete it, but since it's on a Hyperledger Fabric instance, it was more or less immutable. That's more difficult with the public blockchains, with wallets and pricing and all that, but the principles are still there.
Great. Well, thank you so much. And I also just wanted to clarify my earlier statement about APIs not being copyrightable. That's not accurate. It's really what the Supreme Court said. It was a bit silent on the matter of whether or not copyrights are copyrightable. Instead, it said under the fair use doctrine, Google did not violate copyright law, and that the API was indeed used under the fair use test. So I just wanted to make sure I was super clear on that, because I vastly misspoke earlier. Okay, and so we're on to our last LEX talk of the afternoon. And certainly last but not least, I'm pleased to introduce Stefan Eder, partner at Ben Eibler in Austria and co-founder of legal informatics firm Sibley, as well as Elena Montiel-Ponsoda, associate professor at the Polytechnic University of Madrid. Stefan and Elena will be presenting to us on the ambitious LEX project, which is the first European Union legal compliance platform enabled by a knowledge graph. LEX was selected for funding by the EU's Horizon 2020 fund, which was set up to deploy up to 80 billion euro between 2014 and 2021 to advance technology for the sake of solving societal challenges. To me, this is the perfect example of a public-private partnership designed to create a legal Rosetta Stone for the benefit of connecting multiple jurisdictions. Stefan and Elena will provide an update as to how LEX is doing within the context of this enormous effort by the EU to connect citizens of its member countries. Please welcome Stefan and Elena.
Hello, thank you very much, Nicole. Well, good afternoon, Codex friends. It's our absolute pleasure to participate in this great event. So let me thank the organizers again for the invitation, and also congratulate the previous speakers for most interesting talks. I'll start sharing my screen. I hope you can see it. Yes? Okay. So today I'd like to talk to you about LEX. Whoops, probably this is not the right LEX, though it's a beautiful animal. You may agree with me, apparently a smart one. but this is not the type of links I like to talk to you about, of course, but this type of links, right? So the links or connections that can be established between information items, data items, between concepts and references to real world entities, yes? The type of links that allow us to create a graph of data, right? Also known as a knowledge graph, yes? This may be a word to some of you, so you are probably familiar with this technology. But if not, let me briefly tell you that this type of links are considered the foundations of the so-called semantic web. Yes, Sir Tim Berners-Lee's vision of a web in which information items are accessed, represented, linked in a standard way. Yes, so these standards would work like a lingua franca to represent and share data on the web. So they will allow those bits of information to be connected, forming a graph that can be navigated, right? So in the same sense that we used to navigate the traditional web of documents, we can now navigate the web of data. And this is exactly what inspired us, what inspired the project that we would like to introduce to you here today. Yeah, our particular links, yes. So this is the name of the European project we have been working on for the last 3 years, as Nicole well explained in the introduction. It has been funded by the European Commission under the Horizon 2020 framework program for research and innovation. So you may know this is the financial instrument of the European Commission to invest in science and innovation and bring public and private sectors together, the public and private sectors. And here you can see all the entities that have participating in this exciting project. 11 partners, universities, research centers, and companies spread all over Europe, plus an Israeli company. So yeah, this is the links team. So why links? Why semantic web links, right? What did we do with them? What did we achieve with this? So the main idea was to leverage on semantic web technologies to create a graph of legal data. A graph of legal open data. Yeah, data published by official law publishers, which is freely accessible. Yes, so thanks to this link data technology, we can provide a homogeneous access to documents from different sources. Yes, documents from different sources that are not homogeneously identified. Described, structured, annotated. Yes. So here you see documents on the slide. Documents may come from different domains, legislation, case law, industry standards, best practices. Yes. From different jurisdictions and in different languages. And this is a key aspect. As you can imagine, such a graph is very necessary in the European Union, where we have 27 countries with different legal traditions and judicial systems. Yes, and only in the European Union, 24 recognized official languages. So needless to say in this forum that this hinders the access of European SMEs and companies in general to legislation and regulations of other European countries. So our main objective, the main objective of the Links project, was to contribute to reduce the difficulties that companies and law firms in Europe face when participating in this kind of internationalization processes. Of course, we are not the first ones who thought about this, the only ones working on this. There are many efforts going on, and some of them coming from the European Commission itself, who has embraced semantic web technology standards. And I like to mention the paradigm. Worth mentioning is this the paradigm or philosophy behind ELI, the European Legislation Identifier Initiative. Yes, a common way to identify, describe, and publish legal documents on the web that we have also reused when identifying and describing the documents that we have harvested for our legal knowledge graph. So that was the first step, the creation of this graph of data. And in parallel, we created a set of services. Yes, all of them described according to the Open API specification format. Yes, and the set of services that we have created that are available, you can access them from our website. Yes, some of them are meant to harvest documents, yes, legal documents available on the web, and prepare them, format them, right? We convert them into the links format to become part of our knowledge graph. We identify, right, headings, parts, and annotate them with entities mentioned in the text. Yes, places, events, people. And then there are another bunch of services to search and retrieve information from those documents, regardless of the language in which queries are formulated or the original language of the document, which I think is a key aspect, right? So let me briefly give you an example. If I'm an employer, yes, a company expanding in Europe, I need to know how to comply with the legislation that applies to my company or sector. So this is just an example of a common question in labor law, employment law. So if I send this question to a search engine in English because I have no good command of the German language, so apart from putting our links up to sleep because he knows the answer, I would probably get pointers to nice documents from an employee viewpoint, as we all know, but this is not the type of information you need as a lawyer or as an employer. Yeah, so you would be expecting some articles from the Austrian law that you would need to get translated from German into English, for example. Yeah. So, and now I'd like to hand it over to Stefan, who would like to add some more details on other use cases we've dealt with in the project.
Thank you, Elena, and thank you again to the organizers for having us here. Yeah, I'm a partner in Ceremonies, which is an Austrian tech company that runs an open legal database with about 50,000 users and full text database on Austrian law and European law, both in terms of legislative decrees, etc., and as well as court decisions. We in the Lynx project, our company focused actually on data mining in contracts. You could imagine that way that we get documents in one use case about 800,000 documents where we were asked to identify index clauses by a service company, and those clauses should be then linked to legal information that had been retrieved through the database. So for example, this information was about 10 years spread over various companies that had been merged together. The issue was to figure out which of those clauses are still legally binding, which of those might have been overruled. And at the end of the day, the issue was, for example, to calculate the index amounts that could be fixed by mixing the index clauses and the legal decrees that apply to those indexes. That information then retrieved here would then also go into the knowledge graph to be retrievable to the client for future use and further connected to new legislation or new information that comes into the system. So we are sort of as a private partner trying then to use that information and that system to show and to make the use case that's part of the Horizon 2020 strategy to be applied in practice and to be used in private practice. And of course, clearly it's very difficult in 2 minutes to explain that in detail, but actually we were quite surprised that this project actually had a very high accuracy outcome, sort of above 90%. which was quite satisfactory for everybody participating on that particular use case. And similarly, there are other use cases with contract data we are trying to implement. And that sort of should, and that I would like to end our presentation, that should emphasize sort of the objective of the LEX project, where the objective is to identify relevant legal information and to make it usable in a complex legal work across jurisdictions.
Great, thank you so much for that presentation. Looking over, there are a few questions. Let me see. I think maybe you guys can take it. There's a question about the LEX project name having similarity to a text-based web browser. Is there any relation?
I don't think so.
Oh, okay. Well, yeah, it's I mean, a fantastic project. I wish you guys all the best. Where do you think you'll be, let's say 5 years from now?
That's a good question.
That's an interesting question, because the project is about to finish at the moment. So the team is actually touring and presenting the results.
Yes.
And one of the key issues of our discussions now at the end of the project is actually how to take it further and make it usable. So that actually is something we are thinking about, and will be very interesting sort of where we end up. But I think it will be expanded, and hopefully there might be a follow-up project.
I hope so. Is there any history at all, last question, of venture capital coming in and investing in some of the companies that come out of this this category of projects?
This is a quite diverse group in this particular case. We are 11 partners here in this group, a lot of which are universities, and few are industry partners, and most of the industry partners are not typically startups. So I think in our particular case, that question is maybe in 1 or 2 cases, but it would be not generally applicable. If you look in Horizon 2020, I don't have the information.
Interesting. Okay, well, thank you very much. Thank you to all of the LEX Talk participants. It was really an enlightening series of talks. And we're just 3 minutes behind, but I'm happy to turn it back to Roland. Thank you so much.
Thank you, Nicole. Thank you to everyone. And thank you, Nicole, for doing such a fantastic job at emceeing this a portion of LEX Talks. So we have 4 more LEX Talks coming up. We'll take a short break, but at 2:10, we'll pick it up again, and we'll hear folks talk about computational law innovation in immigration, then learnings from the Corona Atlas project, research disposable neural nets, and then government relations management. So tune in again at 2:10, and then we will conclude with our closing panel at 3:20 on the pioneering work of Professor Deborah Rode and the future of legal regulation of regulation of the legal profession. So see you at 2:10. Thank you.